And good afternoon, everybody. Happy, I think today's Thursday. hard to keep track this summer. I'm Paige Duggins-Clay. I'm sitting here. I'm from Austin, but I'm actually sitting at my parents' house in Dallas, Texas. And I know we've got this great virtual convening, folks all over the South. And so I'm so glad to be here with y'all today. This is our wonderful strand session for our Welcoming Communities strand for this awesome conference. And this session is called Establishing and Maintaining Equitable Restorative Communities. And you'll find out very quickly, I'm an overachiever. I hope to cover a lot of material, some of which will be a refresher and some of which may be a little bit new. And inevitably, we may not be able to go as deep as we'd all love to, especially with all of us doing this virtually. But I'm really looking forward to spending this hour with y'all, and I'm really looking forward to answering your questions and hopefully having a little bit of engagement. So just to jump things off, some housekeeping, you'll see in the chat, I've posted a sticky note. I really hope that you'll post questions and, inquiries and comments to me in this chat. It's just me on this panel, so I'll do my best. I'm a millennial, so I like to think I'm pretty good balancing looking at the chat and keeping focus on the presentation. We've got an intimate group, a small group, about, I think, somewhere between 10 and 15 folks. So I really hope we can get some dialogue going, even though it's virtual. And just to test out this feature and see who's paying attention out there, tell me in the chat, I'd love to know who's in the audience. You don't have to say your name, but if you could say what your role or your title is. Are you a 8th grade math teacher? Are you a principal? Are you a counselor? Would love to see a little bit of engagement, and I'll give you all just a second to respond. Hello, is anyone out there? Oh no, I can't have some shy folks in this session. Are y'all able to access the chat? Well, my goodness. Okay, well, we'll hope that we'll get a little bit more engagement as we go along. Let me tell you a little bit about me. I'm Paige. I have a law degree. I'm blessed to call myself an attorney, which is a great honor. I went to the great UT School of Law and have a BA in English and education. So I really am doing my dream job as an education law attorney. And as you see, my minors in race and ethnic studies, I specialize in civil rights law and education law issues. And so I'm really grateful to be here with y'all today. I've got this cute picture. This little guy next to me is actually my son, Hendrix, and he was born just barely 3 months ago. And so I'm showing you this picture because A, he's super cute and hopefully get those positive endorphins going after that lunch break. But just to say I'm a brand new mom of this little one, a little sleep deprived, so bear with me and thanks for your patience and understanding if I have a couple of hiccups. I'm blaming it on that cute little guy because he loves to visit with me late at night and early in the morning. I also like to share, in that same vein, I am the daughter of a teacher. I grew up around schools. I have an education degree, spent a lot of time in schools as part of my education. And I got 4 kids, and they range in age from, I have about to be a 16-year-old, which is crazy, all the way down to this little guy, a 3-month-old. And so I share that to say, in addition to being the daughter of an educator and supporting educators as part of my practice as an attorney, I'm also a parent, and I've been sort of in the trenches with all of you, alongside all of you, both providing services, but also trying to navigate and understand how to best support our kids and our educators in this super challenging year and a half that we've had. And, as optimistic as I am for the future, it's looking like, we're going to continue to experience challenges due to the ongoing pandemic. And so having this conversation about equitable restorative communities in light of so much uncertainty, so many hurdles as we come back. Some of y'all I understand, have been on campus, but coming back onto campus for a lot of others is really important. I know that my 2 older kids, a high school and a middle schooler, they're going back to school for the very first time on campus in over a year and a half. And so it's interesting. I know y'all are out there fighting the good fight, navigating those issues. And Thank you. I think I see Guadalupe. Thank you so much for your response. I'm glad to have you, and would love to hear from other folks who are attending this presentation. Would love to have a little bit of engagement in the chat. So let's talk a little bit about our goals. Like I said, I'm ambitious, and we've got not too many slides. I think you're able to access them through this awesome Big Marker platform. But our goals for today are to do a couple of things. First, we're going to just hit the baseline. What are educator responsibilities for equitable learning environments? And so that's going to be the stuff that you guys get in a lot of different venues and sound bites as in your role as employees of schools and school districts and universities. And we're going to talk a little bit about the applicable laws, federal civil rights laws, guidance. We're not going to spend too much time there because I really want to get to some of our real life scenarios, which I hope I'm seeing lots of engagement now in the chat. That makes me so happy. I'm smiling because I'm excited, because at the very end, I'd love to get to a couple of scenarios where we can work through and brainstorm how we might address some common, or at least in my perspective, real life scenarios. And so we'll do that at the end. And along the way, I'm a big proponent of the concept of restorative justice. And the longer that I'm in this space and that I'm committed to educational equity, the more I find that utilizing restorative justice techniques in response to issues that implicate equity and injustice, I just think it's so important. And we don't have time to do a deep dive on that, but I'll spend just a minute talking about what that means, and we'll try to incorporate that into our conversation, because I think that's really important. Hello, my friend Chloe's here, Emma, Lindsay, Karen, nice to see you guys. We got a Title IX coordinator, so this is great. Lots of folks, and it looks like we have people with varying responsibilities, and so that'll be great. We'll have lots of great perspectives. I'm so glad to have y'all here today. All right, and so with that, let's dive in. And I alluded to this at the very beginning. It's an ambitious amount of topics to work through, and like everything that has to do with your role as educators and supporters of educators, and ensuring equitable environments, there's so many stakeholders, there's so many issues, and we have to strike this very careful balance. It's really almost an impossible balance. And so I'm here to validate you and say that it's very difficult as you're trying to absorb what are our legal mandates, how do we comply, how do we implement best practices, everything is constantly changing, how do we do this on top of being in a pandemic, how do I do this and be a whole human person with my own life and family? And so I know how difficult that balance is. And so that's what we're going to try to work through, and why I really like those practical concerns, because at the end of the day, you see the very first bullet point I have here is the number one concern that we need is how can we ensure that our students are attaining their highest potential and their well-being. And so all these other things, prevention of illegal conduct, First Amendment issues, I have a big asterisk there, because as I know you all know, there's a whole lot of issues that we could dive into with the First Amendment, but we're not. But that is, I just wanted to flag that that's a concern as well. And so really top of mind for us, how can we ensure that our students feel safe, welcome, supported? How can we maximize their potential to achieve positive educational outcomes? And then along the way, overlapping with those, how can we make sure we're not engaging or allowing illegal conduct? That's really going to be the focus. And where there's First Amendment issues, I'll try to flag them along the way. And I said this earlier and put in the chat, but please feel free. The Q&A might be a little bit more difficult for me to keep track of because I'm by myself. But if you go to the chat, the public chat, I have that open and I'll keep that going. So I would love to see it there. Oh, it says attendee chat disabled. Okay, I'll let the Big Marker folks help me with that if that's a thing. And if not, I'll try to go back and forth between the Q&A. Thank you for letting me know that, guys. All right, so just a little bit of perspective. I know we've got people from various backgrounds and roles and institutions and employers. So I just think it's helpful as an attorney, a sort of second nature, think about the various sources of law. But I think for folks who don't have a legal orientation, understanding what is the law is often confusing, and it's a conundrum. And ultimately, it may not be the biggest point or the most important point, but I think it's helpful as we look to ensure and implement equitable policies and procedures that we have at least a working understanding of where all these mandates come from, because folks there's a lot of misinformation out there, and folks like to say that something is law and something is guidance. So let's just clear a little bit of that up right up front. So I think that's going to be helpful as we continue through our conversation. So first of all, we're not going to spend a lot of time on this, but obviously there's the U.S. Constitution. And the most important thing that you guys know about the U.S. Constitution is it applies to protections for individuals against the government. We're not talking about private disputes. We're talking about protections for individuals against the government. And so, and that government, of course, includes public institutions, higher ed, K through 12 institutions, government entities. And so that's one sort of bucket. So when we get decisions from courts about the Constitution, that's the realm that we're talking about. We're really going to focus here on this middle concept today, the statutes, and specifically we're going to be focusing on federal statutes, and specifically federal civil rights statutes. And those are, of course, laws passed by Congress that tell us what we have to do, and they can apply to individuals in addition to public entities. We've got case law, which are opinions that come down from courts that are interpreting either constitutions or statute. And so we won't spend hardly any time talking about case law today. We don't have enough time to dive in, but courts will tell us and give us guidance based on these constitutions and statutes and other general equity principles. And the important thing to know about that is, like statutes, the case law can vary across the country. So I'm here in Texas. I'm seeing folks all over the country, all over the South. And so we may have, you may have an opinion or a statute in Florida that isn't the same in Texas, and that happens with some degree of regularity. And then these final two, we're actually going to be talking about today, regulations and guidance. And so this is important because in the world of equity and civil rights and education, and especially in a world where there's so much political divisiveness, the number one source of guidance and information that we as practitioners get about equity comes from either regulations or guidance. And this is the executive branch, the president, the governor, your regulatory authority. So here in Texas, we have the Texas Educational Agency or the Texas Higher Education Coordinating Board. I'm sure you have other education governing boards all over the state. And then, of course, the U.S. Department of Education. Because of the sort of political myopia that we really have these days, not a lot of statutes are getting passed, and cases continue to go all over the place, all over the country. So we tend to get a lot of guidance in the form of regulations and informal guidance from these various regulatory authorities. And so here we'll talk a lot about the U.S. Department of Education, because that's going to apply to everybody who's in our presentation today. Hope that is helpful context. So, like I said, we're focusing a lot on our obligations to ensure equity under our federal anti-discrimination statutes. And I know y'all know this. Y'all have been in employment law training and civil rights training and Title IX training, so we're not going to spend a ton of time. But just a reminder, the key federal statutes that we're focused on are Title VI, which covers race, national origin discrimination. It's from the Civil Rights Act of 1964. Title IX, which as a education law civil rights attorney, I seem to be spending a ton of time focusing on Title IX, which, as I'm sure everybody knows, prohibits discrimination on the basis of sex for educational institutions. You know, it's super interesting. Title IX is I think something like a 37-word law. Literally, there's 37 words in Title IX, the statute. You know, no discrimination on the basis of sex. And I'm looking at this regulations where there's 2,000 pages of regulations and guidance by the Department of Education. It's very interesting to me how seemingly complicated things have gotten, and we'll try to work through that in the middle of this session. We've got Section 504, which as education practitioners, I know that y'all are implementing at a far more advanced level than even me as an attorney, and the Americans with Disabilities Act. So we're not going to be spending a lot of time on Section 504 or the ADA today, because those are super specialized, but just wanted to ensure we understand sort of the robust scope of these federal anti-discrimination statutes. we're really going to be focusing on what you guys deal with on a day-to-day basis, based on my vantage point as outside counsel, discrimination and harassment. And I know for many of us, we're moving from a virtual environment to an in-person environment, or perhaps a hybrid environment to a in-person environment. And discrimination and harassment are going to be looking different, perhaps now than they did in the last year. And so I think it's really good that we refresh ourselves on what this looks like. And so the two buckets, discrimination, and it's very interesting. Unfortunately, the world is pretty divided, and a lot of these terms, and I know in other strands we're having really deep, important conversations about how to create these equitable spaces, how to reclaim conversations about race and gender and all sorts of protected areas and delicate areas. But the law does have very specific definitions for what we are required to, as educators, as educational institutions, to respond to. So discrimination at its core is, exactly what, your reflexive definition is in your brain. It means I'm treating someone differently. But the key is it's based on a protected category. So we treat people differently all the time. I treat my husband differently than I treat my mother-in-law. I treat my 3-year-old different than I treat my 3-month-old. So what is it about it that makes it illegal? It has to be discrimination on the basis of a protected category. And so those federal civil rights statutes that I just showed, those are the protected categories: race, sex, gender, national origin. And there are many, many other ways that schools, as a matter of policy, can set about having discrimination. And so, for example, we see lots of folks protecting things like genetic history and the way that you wear a particular hairstyle, or other sorts of items. And so, as a school, we're allowed to protect things that's bigger than the federal civil rights statutes, but we're really focused today on what are those core protected categories. So race, creed, color, sex, religion, national origin, age, et cetera, disability status. On the other side, we have what increasingly schools are dealing with, which is harassment. So 20, 30 years ago, we would see a lot of these direct discrimination cases. I am not allowing you to come to school because you do not have the appropriate, documentation to sign up. Thankfully, that is clearly not permitted. There's a great case out of the U.S. Supreme Court that talks about that. Now, what we tend to see more of, instead of that sort of direct discrimination, and not that it doesn't happen, but it happens less often than what we call harassment. And that's behavior, and it can be any kind of behavior: verbal, physical, written, gestures, et cetera. And it has to be unwelcome, offensive, and it has to interfere with, in our case, an educational environment and the ability to access education or programs affiliated with education, athletics, student organizations, office hours, you name it. It creates this hostile environment. So we're going to talk a little bit about what that hostile environment is, because that is the area where we see a lot of confusion and questions about how to identify it and how to respond to it. And so what we call this hostile environment, it means that because what someone is saying or doing is so severe, pervasive, or persistent, and those are words that each have their own individual meanings. And again, they prohibit that person from accessing education. So severe, it's very serious, it's extremely harmful, it's a single act of violence, a single name calling or statement that is beyond all bounds of decency. That's severe. Pervasive means maybe it's not this really serious high-level incident that occurs once, but maybe it's something that's happening over and over again. Maybe it's even just a little thing, one name that's being called over and over after someone's told someone to stop, one inappropriate touch, that sort of framework. And persistent, again, similar to pervasive, but persistence has its roots in the idea that someone is telling you, I don't like this, stop, and the behavior is persisting. So we're looking for conduct in order to establish this hostile environment. It's got to be severe, pervasive, or persistent. Then has to be all three, can be any of them, so that it interferes with their ability to participate in school. And, you know, people ask me all the time, Paige, you know, give me the formula. How do I know that this is harassment or this is a hostile environment? And the reality is that's just, there is no formula, there is no silver lining. It always depends on the facts and the circumstances. It can range based on the type of misconduct. Again, are we talking about name calling? Are we talking about physical harassment? Are we talking about online or virtual harassment? All of those things are cognizable reasons that a harassment claim could stand. How often is it happening? Again, pervasive, persistent. Where is it occurring? Is it occurring in the middle of class where everybody can see? Is it occurring in the hallways, in the passing period? Is it occurring in office hours or at band practice? Those factors will play into our analysis. And of course, is there a power differential? Is the harassment being perpetrated by an older student against a younger student, by a teacher against a student or an administrator? Of course, all these concepts apply to inter-employee issues as well, but we're really staying focused on the educational environment for students today. And finally, when we're assessing whether there is a hostile environment, we're looking at it from the perspective of a reasonable person. And again, I know we're politically divided and everyone is very touchy on all sorts of topics, and everyone has different perspectives on what could or is discrimination or harassment. And the law is clear. Our charge is to say, from the perspective of a reasonable person, would that person find that the conduct is inappropriate, offensive, and creating that hostile environment? And so the reasonable person standard, like I said, folks probably have different ideas about who's reasonable and who's not. But, you know, in the law, we like to say the reasonable person who you're sitting next to, you know, maybe on the bus, or sort of the median person, not a person who is, you know, super, what we call an eggshell plaintiff in the law, not somebody who's super, super sensitive, and not someone who's super, super brash, but someone in the middle, someone mainstream. That's what we're using as the baseline for our reasonable person standard. All righty, you guys still awake out there? I'm glad to see a couple more folks posting their affiliation. Welcome to the session. Nice to see y'all. I'm seeing U.S. Virgin Islands. I'm going to be 30 this year. I'm thinking about taking a vacation there, so maybe I'll have a chance to connect with you. All right, and so this is the baseline. What happens when we've established that discrimination or harassment has occurred? Well, it should be obvious, but, you know, just in case, we got to respond to it. And our response has to be reasonable. It has to be under Title IX, not deliberately indifferent. And really, there's a lot of legal jargon about what has to happen, but the baseline is very simple. We got to make sure that the discrimination, the harassment is stopped immediately, and that it doesn't happen again. And then in addition to that, we've got to make sure that whoever is harmed by that discrimination or harassment is able to regain their opportunity to participate in education. And so those are really the components. We have to stop the harassment. Yes, thank God. I'm going to look into that. Thanks, Paige. We have to look at, you know, stopping the harassment immediately, preventing it from happening ever again. That, you know, that could involve a range of options. We'll talk about those later. And taking care of the person who was harmed. And that's where restorative justice, from my vantage point, comes in. I love to consider those restorative options where it's appropriate. And all of those things have to happen promptly. And so everyone else says, Paige, what does promptly mean? And I'll give you the really typical legal answer. It depends. But it means that we have to work as quickly as possible and remedy the situation as soon as possible. That may mean separating students immediately. It may mean initiating an investigation. It may mean providing some kind of support, resources, medical assistance, counseling. We'll talk about some of those options in just a moment. But bottom line is, when we are on notice of some sort of discrimination or harassment, we have to act. We can't put our head in the sand. We have to take steps to make sure it stops, it doesn't happen again, and the person who's harmed is taken care of. And what can we do? So this is where, unfortunately, I actually think it's a bad thing that lawyers have had to get more and more involved with educational operations as time has gone on. I really think that it's become a really contentious space, a really complex space. We're going to talk about Title IX in a minute, that has become increasingly complex. And so the short answer is, when we ask ourselves what would be appropriate to address some kind of discrimination or harassment, it's really going to depend on how serious, what is the nature of the allegations? Can we handle it informally in the classroom? Do we got to refer to the principal or to some other disciplinary authority? Do we have to engage in some kind of formal investigation? A lot of that is going to be determined based on those specific legal mandates. So again, we're going to talk about Title IX in a minute, which has its own legal framework for how we have to respond. And we have very little discretion about how to do that. And that may be different than how we respond if the allegation is some sort of racial harassment or national origin discrimination or disability discrimination. Of course, disability law has its own robust set of protections and complaint process for addressing those sorts of situations. So we're asking, what is the nature of the allegation? What is the protected category? What law applies? How serious? Where did that complaint come from? Did it come from the mouth of the complainant, the student, or maybe your coworker? Did it come from a community member or a parent? Where that complaint comes from may inform how we respond. What's the age of the person that we're dealing with? If there's a complaint coming from a kindergartner, that's going to look a lot different than a complaint coming from a high school student, a college student. Again, those specific legal mandates, certain laws, especially Title IX, have really prescriptive steps for how we have to respond. So we always be checking in with our leadership and counsel, if you have it, about those sorts of cases. And then, as a practical matter, how our response is going to be informed by how big our school is. Who can support these efforts to address the harassment? Do we have an independent investigator? Do we have adequate counseling? Our response naturally is going to be limited or augmented by the size and the administrative structure. So all of those things are going to impact what we do to address harassment. And you guys are experienced. Some of the common examples are, immediately, can we separate the students who are experiencing, whether perpetrating or the victim of the discrimination harassment? Are we providing, and this is, in my perspective, one of the most important ones, are we providing those support services? Are we checking in with the person who is impacted, making sure they're not falling behind in their coursework, or that they're not injured, or that they're not emotionally unstable, that they don't need those additional resources? And then, of course, a cornerstone, unfortunately or fortunately, depending on your perspective, of our response is a disciplinary process. Are we investigating formally? Are we having a process where folks are submitting statements and we're deciding who's telling the truth or who's not? Are we doing that informally? Are we meeting with the teacher, having a parent conference? All of these examples are, again, going to be informed by these various factors that I've laid out here. And, I hear this a lot from folks, whether it's from educators or principals or even from students, and they'll say, well, I wasn't engaging in harassment, and we were just having fun. We were just, playing a game, or I was just teasing. I didn't mean to, cause this person harm. And the bottom line is, really, the label doesn't matter. And I'll put an asterisk next to that because, and here again, this is our restorative approach. The label doesn't matter from the orientation of we are deciding whether or not discrimination or harassment occurred. So intent, a person's intent in causing that harm, is not going to change if the person experienced the harm and if it meets the legal definition of discrimination or harassment. So we'll do a hypothetical here at the end that tests out this theory. Just because a bullying incident or a bully says, oh, I didn't mean to do it, that doesn't mean that the person who experienced the bullying doesn't have a discrimination or an equity claim. It may, this is why I said that asterisk, it may impact whether and how we proceed with a formal or an informal resolution of the matter. So in other words, if a person says, look, I didn't mean to hurt this person or, make this person feel bad or harass. I didn't mean to harass them. I'm sorry. Well, that might be a sign that maybe we shouldn't go down the path of this formal, ultra-disciplinary, exclusionary discipline. Maybe we need to consider other options to the extent we have flexibility or discretion to do so. And we'll talk about that again in just a little bit when we talk about restorative justice. And again, I remember I set us up at the beginning, whether it was coming from the source of the law that this was coming from, regulations, guidance, statutes. So this is a quote from the 2010 Department of Education's Office for Civil Rights. You get lots of guidance from them in the form of what we call Dear Colleague letters. And they've made clear the label used to describe an incident does not determine how a school is obligated to respond. Rather, the nature of the conduct itself must be assessed for civil rights implications in accordance with the applicable laws, statutes, regulations. So again, label doesn't matter. If someone is reporting that they're feeling uncomfortable, unhappy, that something isn't going right in the education environment, we need to respond, and we may need to take action even if the person who's alleged to have engaged in that conduct says, I didn't mean to do it at all. All right, so we've done just sort of cursory tour of the big picture on our obligations to respond to civil rights concerns, and really specifically race, national origin, those, more general status protected by Title VI and by the ADA, et cetera. We're going to focus for just a couple of minutes on Title IX because I used to not have to do this, but now there are such specific, robust mandates and regulations around this. We really got to spend some time distinguishing how Title IX has its own separate set of required responses. But before I do that, I'm going to pause, take a sip of water, and look at the chat. Does anybody have any questions where we are now? And remember, you can post them in the chat. I understand that it's enabled now. And remember, you can post them along the way, and I'll keep an eye out. I think it gets pinged every time we get a little chat. All right, so let's talk about Title IX. Title IX, at its core, like I said, it's a very simple law, something like 30-plus words. Lawyers have gone and made it very complicated. At its core, it prevents discrimination on the basis of sex, and it has a very specific definition of discrimination and sexual harassment in the regulations that's different than what we just talked, slightly different than what we just talked about. So there's three. The first is what we call quid pro quo harassment. And quid pro quo, going to get all tongue-tied here, is Latin for this for that. We'll talk about that in just a moment. But it basically means you're conditioning someone's participation in education or employment on sexual harassment, on a sexual act, sexual favor, etc. We don't see as many of those. We see those most often in the form of inappropriate educator conduct, so a teacher or a counselor or a coach. That's the sort of scenario. We don't really see that with student on student, but we can. Anything can happen. The second is really where we get the most of our Title IX complaints. Unwelcome conduct, again, this is our hostile environment standard. Unwelcome conduct that's severe, pervasive, and objectively offensive. Notice that we're getting a little bit more precise on the word. It has to be severe, pervasive, and objectively offensive. Folks argue about whether or not that and is significant or not. I don't think it is. If someone's reporting that it's impacting their educational environment, we're going to investigate it regardless. And then finally, this third category is new, and it's very specific to sex discrimination, and it's any instance of sexual assault. And the definition of sexual assault is defined in a federal law called the Clery Act. Won't bore you to tears. It's a law that applies to higher education institutions, but it talks about what sexual assault is, and essentially it's any penetration of a person, using any body, whether it's a digit, whether it's a forcible entry. That is how the Clery Act has really pages and pages of specific definitions, but at its core, penetration of a sexual organ doesn't matter. with any sort of object, digit, etc. The other three categories come from a federal law called VAWA, the Violence Against Women Act, and those are dating violence, domestic violence, or stalking. And these have, each of these definitions, dating violence, domestic violence, or stalking, have their definitions in state law roots. So whatever state you're in, Title IX adopts essentially by reference the legal definition of dating violence, domestic violence, or stalking. And so we actually have a hypothetical in just a minute that will test our understanding of those concepts. And before I move forward, I see that I have a question. I recognize it's about discrimination, but with this faux anger about critical race theory, I've heard white parents complain that their kids' feelings will get hurt, aka reverse discrimination. Do you see this as being problematic? So let me take a step back. I think it's Dave. There's an R there, so I don't know if you go by R Dave or Dave, but great question. We could have lots of great coffee table or maybe even happy hour discussion about this. And I do think that a lot of this anger about CRT is a red herring, particularly with respect to our compliance with civil rights laws. And so under the previous administration, there were real efforts to make sure that, and to really prescribe what educators can teach and what employers can train their employees on. There's a big effort to eliminate concepts like white privilege, like racism, like critical race theory from our curriculums. And as David pointed out, it's been rooted in this argument, and I'm calling it an argument, I'm not saying whether it's legitimate or not, that it is this reverse discrimination. If you're teaching folks that, there is a history of racism or that someone benefits from privilege on the basis of their race, that is somehow discrimination. I will say this. I have not yet read a case or read a law. Well, I say read a law, but I live in Texas, so things are changing rapidly. At least today, where someone has held, a court has held that teaching or talking about critical race theory concepts is discrimination. And we have to just zoom out and focus in. If we're talking about compliance with these civil rights statutes, the question is someone unable to access their education program, and is it because of their race? And if all we're doing is merely educating about history and we're teaching from a certain perspective, I have a hard time believing that that's going to be a cognizable civil rights claim, and so long as we're doing it inclusively. Now, the difference is if we're teaching and a teacher is standing up and saying, Susie Q, and let's, for the purpose of this hypothetical, suggest that Susie identifies as a Caucasian student, and it's Susie Q's fault that the students in this class today are not being successful, and directing something to a specific student based on his or her race, that would certainly be discrimination. But that's not my understanding of how critical race theory works. I know there's great experts in this panel and in other sessions who are talking about that. So as long as we're not singling out students and making them feel uncomfortable personally based on their race or other identity status, from my perspective, this isn't legal advice, but from my perspective, I've not yet seen a theory that recognizes that as discrimination. I know that was a long aside, but it's a great question, one I've been thinking a lot about, and one that a lot of the schools that I'm working with, particularly in Texas and across the South, are grappling with. So thank you for the question. Getting back to sexual harassment, we talked a little bit about quid pro quo. Thank you. Very nice, Dave. And so one of the things that we deal with a lot and that I get a lot of questions from educators about is what the heck are these regulations and do I have to comply with them? Because like I suggested earlier, these new Title IX regulations, which came out under the Trump administration in August 2020, they do apply to colleges and universities, and they also apply to K-12 institutions. And there parts of them can be quite cumbersome from an administrative perspective, setting aside that there's been many advocates and groups, particularly groups around who represent survivors and victims of sexual misconduct, who suggested that they sort of get in the way or obstruct equity because the process for dealing with complaints has become so cumbersome. So Implementing them is a challenge, and so folks are frequently trying to figure out, do they apply? How do I comply if they do? So I want to be very clear about where these new regulations, these 2020 regulations apply. It applies to what we call sexual harassment. And remember, sexual harassment is what we talked about in the previous slide. You know, it has to be sexual assault, domestic or dating violence. It has to be quid pro quo or meeting a hostile environment. So it has to meet that definition of sexual harassment, and it has to be within our education program or activity. And you would think that these are sort of common sense words, but they really have specific meanings under these regulations. And so let's take a step back. Like I said, like I started with, Title IX is a law that prohibits discrimination on the basis of sex. There is a whole bunch of sex discrimination that is not covered by the definition of sexual harassment under these regulations. So for example, I was just 3 months ago very pregnant on the eve of our summer, and there's a federal law that prohibits discrimination on the basis of pregnancy status. It applies to students who happen to be pregnant, and it says you can't discriminate on the basis of pregnancy status. That's sex discrimination. These regulations do not cover the Pregnancy Discrimination Act. You have a different process. A student comes forward and says, hey, my teacher won't let me join the band or the club because I'm a woman or because I'm a young man. That sort of direct discrimination that is not sexual harassment, you still have to respond under Title IX, but you don't necessarily have to use the Title IX regulations. And I know this is sort of, making your head spin potentially, and it can be difficult to navigate through, but the main takeaway that I want you guys to have is what I have down here in red. It does not matter even if the Title IX regulations do not apply, we still as educators and as schools have an obligation to respond. It just means that the regulations just prescribe whether or not we have to respond in a particular way, and we'll walk through a little bit of that in just a moment. So sexual harassment, we walk through the definition of what the Title IX regulations, how they define sexual harassment, and it has to be in that education program or activity. So on school grounds, in a school-sponsored activity, in a club, if you're traveling for a sport, if you're on the school bus, all of those sorts of things. It doesn't apply if you're off school grounds, and that was controversial. But again, just because the regulations don't apply does not mean that we as a school or as educators cannot set other standards that we enforce through our regular student handbook, student codes of conduct. It just means that the Title IX regulations don't apply. Let's just hit a quick example. Let's say that a student A reports that student B sexually assaulted. Our antenna should be going off. That is a term, that is a definition of sexual harassment under the Title IX regulations. So we've got sexual harassment. Student B sexually assaulted student A 3 weeks ago in a private off-campus house. There wasn't a student organization event involved, and there wasn't a school employee involved. Obviously, if a teacher is going to a student's home and sexually assaulting or harassing a student, that would count. But just we're talking about 2 students. If there's no other claim of misconduct, are the Title IX regulations going to apply? No, they don't apply. Does it mean that if student A comes to you and says, hey, student B assaulted me and he's sitting in the chair next to me, does that mean that we don't do anything? No, obviously not. We still have an obligation to respond and to assist that student and provide support and resources and prevent that discrimination from happening again. It just means that we don't have to necessarily use the really prescriptive mandates of the Title IX regulations. Here, if there is nothing else that you take away from this session other than the fact that I have a really cute baby, and I know that you think he's adorable, his picture's in the first slide. There's nothing else that you take away. Here's what I want you to understand. Your school is on the hook for being informed of sexual misconduct if any employee of your school knows about it. Any employee. Doesn't matter what your status is, if you're a teacher, you're a principal, you're a custodian, you're a cafeteria worker, if any employee at your school is on notice of some form of sexual harassment under these regulations, your entire school is on the hook for responding appropriately. What does that mean? It means that if you have any suggestion at all, if you think that what you are hearing, observing, seeing, what someone told you, and whether you saw it on social media, if you have knowledge and you are a school employee and you think that it may be sexual harassment, you need to call your Title IX coordinator or otherwise follow your school's process for reporting that information. I know some of you guys go through your principal, who then goes to a Title IX coordinator. The bottom line is, if you know about it, you got to tell somebody, because at the end of the day, if it comes out that you knew about it and your school didn't, your school is still going to be on the hook for failing to appropriately respond. Now, I know that a lot of folks, particularly teachers, have concerns. They say, well, the student came to me in confidence and she said, or he said, look, this terrible thing happened to me. I just want to talk about it. I don't want you to tell anyone, so I don't want anything to happen. It does not matter. For your protection and for your school's protection and for the well-being of that student, you are absolutely required to report that information to up the appropriate channels, but at a minimum to the Title IX coordinator. If you don't know who your Title IX coordinator is, you really need to find out, because that's really, from my perspective, one of the most important takeaways for K through 12 schools under these regulations. Get the information to the Title IX coordinator. And if you're worried about what's going to happen, or if the student is worried, wow, I really don't want to lose control over, this situation, I just want support, that's fine. When a school is on notice, we have what's called actual knowledge of some form of sexual harassment. What's our obligation? We have to reach out and ensure that the impacted person, the reporting individual or the victim, has what they need, that they get support and resources, and that they understand their rights and options for pursuing a formal complaint. So the little boxes here are the words taken directly from the regulations. Once the Title IX coordinator or the support person that they've designated gets that actual knowledge, they're going to reach out to the complainant, who's the person impacted, the victim. They're going to talk about what are some supportive measures that we can do. We're going to talk about about the availability of how these supportive measures work. We're going to talk about their rights to file a complaint and have it resolved formally. And we're going to talk about the process for it. That's it. And folks have lots of worries about that. That is what's going to happen. And when a school is trying to assess what steps to take, remember we had all those factors, the nature of the allegations, the legal mandate. Under Title IX, the school is obligated to assess it and to find out, okay, what does the complainant want? What does the student or the victim want? How do they want this resolved? And can we honor that request and also keep our school community safe? And so in many cases, a student would say, hey, I was sexually assaulted off campus, and I really just want counseling to work through this situation, but I really don't want this person to get in trouble. Well, we have an obligation as a school to evaluate that and say, wow, we want to honor your request, we want to support you, but we have to make sure that this student isn't going to hurt any of our other students. And so that's the analysis. Overwhelmingly, we endeavor to honor the requests and the preferences of the person coming forward, but particularly when we're dealing with these younger, vulnerable populations, we're going to be making determinations based on all the factors about how to move forward. But that's what happens when any employee, and just to be clear, school librarian overhears two students talking in the library. They're using their inside voices, they're whispering even, and the librarian overhears student A say, I was sexually assaulted in a classroom. So now we've got education program activity. We're on school campus after band practice. Student A is crying. She's not going to class. She's thinking about filing a complaint. Here, can the librarian say, look, I hear she's gonna file a Title IX complaint. I don't have to say anything. I don't have to do anything. I'm gonna pretend like I didn't hear that whispered conversation. Can the librarian do that? Absolutely not. Librarian needs to pick up the phone, send an email, walk down the hall to the Title IX coordinator or the other designated campus representative and make that report, because at that moment, the school is on notice of some kind of sexual harassment. I hope that's clear. If you have any questions at all, I know that most educators or all educators are familiar with these mandatory reporting requirements for child abuse or other sorts of abuse. This is effectively a mandatory reporting requirement. If you're on notice, get it to the Title IX coordinator or other representatives. So we've only got about 10 minutes here, so I'm not going to spend a ton of time, but I want to talk just a minute about how and flag for you that in the midst of all these really prescriptive, rigorous, investigative, adversarial processes that the law often encourages us or points us towards using, I'm a huge proponent of another way, and that's the way of restorative justice. And I first started getting involved in restorative justice as an undergraduate student, continued that work in law, and so some of you guys may have had access to it, whether you're using it on your campus already. Maybe you're doing things like youth court, which is a quasi-restorative, or you're already implementing restorative circles as part of your social emotional learning programming. But increasingly, I'm encouraging and I'm seeing schools using these restorative responses in the context of student discipline. And I think that's really important for a lot of reasons. First, it says something about who we are as educators. This is my friend David Karp. He runs the Center for Restorative Justice at the University of San Diego. And he says, the way we respond to student misconduct symbolizes the kind of community we aspire to be. RJ offers a different approach that's educational while also meeting the needs of the harmed parties and the institution. And I think it's important that we have that orientation. At the end of the day, we've got these, kids ranging in ages in our school, and it's our job to get them through school and hopefully get them through it in a way and graduate them with this perspective and this life framework, which is not just spitting out sort of in the little robots, but citizens of this country and of this world and participants in our community. And we want them to have this orientation. So what I like to show this slide because I like to center myself on what's at the bottom here, restorative justice. We're making the assumption that our students are moral actors, that they're capable of redemption, that they're capable of growth and learning. And disciplinary responses that focus on restorative justice or use restorative justice really center that belief that our kids are worth fighting for and worth keeping in our communities. And then you can see we get progressively more exclusionary with these other forms of discipline. So deterrence, we're giving students fines, taking away their privileges, suspending them. Deterring them assumes that students are rational, right? Like, oh, they don't want to experience this discomfort or pain or lose something, so we're going to just use deterrence. Again, I like to think that our students are capable of learning and absorbing the moral lessons that we're trying to teach them, but that's deterrence. And of course, incapacitation means we're expelling them. We're suspending them for an extended period of time. We're taking them out of our community. And that brings me to the second reason that I think it's so important that we utilize and focus on restorative justice. And that's because we all know, I know everyone in this virtual room understands the impact of the school to prison pipeline, the disproportionate impact of exclusionary discipline on the communities of color, on students with disabilities, on Black male students specifically. And so for all of us, as we look to center ourselves and create these welcoming communities, as we reorient ourselves, coming or continuing in, but hopefully coming out of the pandemic, we really want to center those concepts in our responses to these actions. So we have about 7 minutes left. If you want to engage on restorative justice, I would love to. I'd love to hear how you're doing it on your campus. You have my contact information. Would love to continue that conversation. But let's work through a couple of scenarios just to test our understanding. And here, please feel free to use the chat to engage if you would like to do that. And I know we have a strict cutoff at 2:30 because we're going into our keynote. So I'll make sure and end this on time, Dr. Johnson. All right, so here's our first scenario. Our teacher observes bruising on student A's face and arms and notices student A looking tearful and afraid when student B sits down next to her in class. The teacher has previously observed student A and student B holding hands and passing notes to each other in class. Student A failed to turn in a homework assignment that morning and is distracted and unfocused in class. All right, I'd love to get some engagement in this chat. what is there any sort of prohibited or any sort of misconduct or discrimination that we should be worried about? Or you can tell me what federal law is implicated by the facts that I'm giving you here in this scenario. Just give y'all a minute to focus on that. All right, I know we're running out of time, so I don't get to smoke y'all out, but here we have a classic Title IX case. This is a dating violence scenario. We're seeing that the teacher has previously observed the students holding hands and passing notes. That suggests that there's a romantic relationship. We're noticing bruising on the face and arms. Exactly, Dave, the relationship is established. We've seen those facts, and we're noticing those face, bruising. We're noticing the student reacting to the person sitting down next to them. These are the sorts of facts where when we see it, we are on notice potentially that some form of sexual harassment here, dating violence has occurred. And what are we doing? We are not necessarily picking up the phone right there in class, but we're checking on the student, obviously, first and foremost. We're making sure that they have the care that they need, but we are getting that information as soon as possible to the appropriate folks to respond. That's exactly right, Karen. It looks like dating and domestic violence. And I just want to flag here, we've got bruising on the face and arms. So we should already, as educators, we're talking about this welcoming environment. We're already worried about the student. We want to check in. But it's the fact that it's dating violence, this element of sex discrimination, which triggers our obligations and very, very specific obligations to get that information to the right people, the Title IX coordinator or their designated representative. Exactly, Guadalupe. You're responsible to report. You see this. It doesn't matter that student A didn't tell you about it. It doesn't matter that it wasn't a verbal conversation. You have observed it, and it's your obligation to report so that that student can be taken care of. Thank y'all so much for your engagement on that. All right, let's try a different scenario. And again, these are all real cases that I've worked on with schools and worked through, and unfortunately, a variation of this one happens a whole lot. During a class lesson which involved discussion of law enforcement, a 5th grade student mutters loud enough for several classmates to hear, "F the police." Several students snicker, others nod, and others shake their head and say, "Shut up." So this, I'm so glad that Dave asked this question earlier about CRT and reverse discrimination. It's not exactly what we have presented here, but I just want to make clear, here the person who's being, or the identity group that's being disparaged is the police, F the police. That's clearly a disparaging tone. Are police officers protected by any federal law when it comes to civil rights? No, they're not. They are not a protected category or class. So here, we don't have a case of discrimination as, potentially inappropriate, using the F word, derogatory towards folks with authority. This is not necessarily a civil rights discrimination incident. It is, however, a disruptive incident, and we may need to respond under our codes of conduct. I'm laughing because I have a 16-year-old and he tells me all the things that kids say. So I know we're not always referring every single incident for discipline, but this is a case where maybe we're looking at an opportunity for restorative justice. Clearly there's some disruption, and clearly as an educator, we may want to take an opportunity to work through this and find a way to address the emotion that the student is experiencing. And yes, maybe we need some kind of discipline for using the inappropriate word, but maybe we can structure that in a way that's restorative as opposed to punitive and exclusionary, particularly given our national climate. Okay, we're coming towards the end of our time. I think this last scenario, 3, will be our last one. The 4th one sort of speaks to itself. At recess, we have elementary age students, and they invent a game called Catch the Illegal. Again, this is a real case. In which the students chase others, in some instances grabbing their arms, putting their arms behind their back, touching them, and bringing them to a judge to be deported. Of course, I hope this is obvious in this upsetting incident. On its face, is this a discrimination or harassment incident? Yes, we have potential harassment here. We've got national origin discrimination, Catch the Illegal. Certainly it's not overt, but it has undertones of national origin harassment and discrimination. And we're going to be taking steps to address it and stop it. I see we're almost out of time, so I don't want to take another step, because I want y'all to make it on time to your awesome keynote. I know this is a lot to unpack. I know it was an ambitious agenda. I'm so grateful for y'all's participation, for your time, spending this hour with me. This is my first official day back at work from maternity leave, and it means so much that I've been able to spend it in fellowship with you all, fellow Equity Gadflies. So thank y'all so much. Please feel free to reach out. Would love to continue to connect and continue the conversation, and enjoy the rest of the conference. Y'all are amazing, and I wish you all the best in this upcoming school year.